Hello everyone, in this video we will be learning about Arbitration and Conciliation Act 1996. We have already uploaded two videos on this topic which covers the fundamentals of arbitration and the sections up till section number 29. In this video we will cover the remaining part of the arbitration. Please watch those two previous videos before you get into the video. This will help you understand the Arbitration Act in a deeper and a full holistic manner. So let's get into the topic. By the way, I will give the link of those videos in the description of this video. In the previous video, we have completed up till section number 29. But if you closely watch the video, I have skipped a section which is section number 28. We will be starting today's session from section number 28. Let's read the text of the section. Rules applicable to the substance of the dispute. Section 28.1, where the place of arbitration is situated in India. As I already said, the word place is equivalent and used by meaning the word seat. We saw the concept of seat of arbitration in the first video that we uploaded for the Arbitration Act, where the seat of arbitration is in India in an arbitration other than international commercial arbitration. So this means domestic arbitrations. For domestic arbitration, where the seat of arbitration is in India, the arbitral tribunal shall decide the dispute submitted in accordance with the substantive law for the time being forced in India. In this section, what they are saying is that this is a domestic arbitration. That is other than international commercial arbitration, and both of the parties are Indian parties, and the seat is also in India. So this should be decided according to the Indian law. And the subsection 28.1b. In an international commercial arbitration, the arbitral tribunal shall decide the dispute in accordance with the rules of law designated by parties as applicable to the substance of the dispute. In case of domestic arbitration, where the seat is in India, it should be decided by Indian law. In case of international commercial arbitration, here also the seat is in India, but it should be decided by the rules as applicable to the dispute designated by the parties. In the arbitration agreement, the parties will have written that which law will be applicable, according to which law the arbitration should happen. This will be given in the arbitration agreement. That rules you have to follow. Any designation by the parties of the law or legal system of a given country shall be construed as directly referring to the substantive law and not to its conflict of laws. When the parties have written in the arbitration agreement that it is referring to the USA law, we will be conducting the arbitration according to the USA law, then you have to conduct according to the US law. This is the simple meaning of this point. Failing any designation of law under clause A by the parties, the arbitral tribunal shall apply the rules of law as it considers to be appropriate, given all the circumstances surrounding the dispute. Here, in this section, the law has given the power to the parties to designate the law. Which law they have to follow, they can choose it. But if they do not choose any law, the tribunal will decide which law to follow. They will decide the appropriate law and conduct the arbitration according to it. The arbitral tribunal shall decide ex quoto et bono or as amiable compositure only if the parties are expressly authorized to do so. Many times when we decide the issue, we will be strictly following the law. This is one type of approach, strictly following the law. And there is another type of approach where we will not be strictly following the law, but we will be giving the decision based on fairness and equity. Here we will see the fairness and whether it is right or wrong. In that sense, we will be taking the decision. If we strictly follow the law, it is an approach. If we decide based on fairness and equity, it is another approach. Here, the meaning of this Latin term is deciding based on fairness and equity. The arbitral tribunal can decide the case based on fairness and equity only if the parties expressly authorize the tribunal. The parties should tell the tribunal that you can decide the case based on fairness and equity. Generally, in other cases, the arbitral tribunal should strictly follow the law, and only when the parties expressly expressed, then you can follow it based on fairness and equity. While deciding and making an award, the arbitral tribunal in all cases take into account the terms of the contract and the trade usages applicable. In every transaction or every field, there will be certain trade usages that you have to take into account while making the decision. That is while giving the arbitral award. There is also terms of the contract. There will be a main contract. For example, purchase agreement or rent agreement or sale agreement. There will be a main contract. In that contract, we are getting a problem. That is why we are going to arbitration. So in the main contract also, that also you should consider while making the arbitral award. Now I have given a summary of section 28 here, where the place of arbitration is in India. That is, the seat of arbitration is India. There are two cases other than international commercial arbitration, that is domestic arbitration, and the international commercial arbitration is the second case. In case of domestic arbitration, the arbitration should happen according to the law in India. In case of international arbitration, the law will be designated by the parties, or they will not designate the law will not be designated by the parties. If the law is designated by the parties, the rules of law will be as applicable as designated by the parties. The law designated will refer to the substantive law of the country. If the law is not designated by the parties, the appropriate law will be decided by the arbitral tribunal. And subsection 2, based on fairness and equity, the tribunal can decide the case only when the parties expressly authorized. They have to give in writing or in oral, they have to tell it. The arbitral tribunal cannot follow it automatically. It should also take into account the terms of contract and the applicable trade usages for the transaction. This is all about section 28. Let's move to the next section. The next section is section number 29A. This is given for time limit of arbitral award. Arbitral proceedings we are going to because we are not preferring the court because of the time delay. We need quick solutions under arbitration. That is why we are coming to this alternative dispute resolution method. So we have capped the time limit for up to 12 months. We should complete the arbitration within 12 months. From which date you will calculate this 12 months time period? From the completion of pleadings. As we saw already, while in the arbitration proceedings, we have 4 steps, like statements of claim and defense, hearing and proceedings. Like that we have 4 steps. In that, the step 1 is called statement of claims and defense. This is called completion of pleadings. All the claims will be settled, and after that the hearings will start. This when the date on which the step 1 is completed, that is the date from which you have to calculate the 12 months. If the statement of claims and defense is completed on 1st April, then from that you have to add the 12 months. For example, the statement of claims and defense is completing on 1st April 22. From that you have to calculate 12 months. Then 1st April 23 will be the time limit for the arbitral award under section 29A. The next point is parties consenting can extend the time period for a period not exceeding 6 months. For example, in a case, the time limit is completing on 1st April 23. Up till 1st April 23, they have not given an arbitral award. So now what we can do? We can extend the period. For how much period we can extend? We can extend up to 6 months. If the award is not made within the time, within the 12 months or within the 18 months, if it is not made, what will happen is the arbitrator will be terminated. The office of the arbitrator will end and we have to appoint another arbitrator. And if the award is not made within time, another problem is also there. There will be reduction of fees, maximum 5% if the award is not given timely. That is not a flat 5%, it is a 5% for each month of such delay. For example, if the arbitration fees is 1 lakh rupees and you have made 5 months of delay, 5% of the fees, 5,000, will be deducted for every month of the delay. That is meaning that 5,000 is for 1 month of delay. We have done delay for 5 months. So totally 25,000 will be the reduction in fees. So 1 lakh is the early decided, 25,000 is the reduction. Now in the end you will get only 75,000 fees. This is given in section 29A. Additional fees for timely award. As we are giving punishment, reduction in fees for a late award, we have to give an incentive or a gift like that for timely award. If an award is made within 6 months from the date of arbitral tribunal entering, additional fees as the parties may agree. The date on which the tribunal enters the case, like the date on which it is appointed, from that if it is completed within 6 months, the arbitral awards given within 6 months, then additional fees will be given to the tribunal as the parties may agree. This will be decided by the parties. How much additional fees we should give, that will be decided by the parties. The extension for 6 months we told, right? Earlier the period will be 12 months and if it is not completed, you can extend up to 6 months. This 6 months extension will be given only if sufficient cause exists. Only if there is a proper reason behind the delay, only then the 6 months extension will be given. For getting the 6 months extension, you have to apply to court. And when you apply to court, the court will see whether you have a proper reason or not. The court may take a decision to substitute the arbitrator. The court may say that this arbitrator is not working properly. We can make another arbitrator and decide the case. We will give you 6 months extra. Like that the court can tell. The new tribunal shall be deemed to be in continuation. When the old arbitrator is going and we are getting a new arbitrator, he will be deemed to continue the case. He need not start from first. He need not start from scratch. The next point in this section is application for extension should be disposed of by the court within 60 days. If you apply to the court for extension, within how much time the court will give you the order? If you apply on 1st April 23 to the court for extension, the court can maximum give you the order within 30th May 23. Only 60 days is the time for court to decide whether you have to give the extra 6 months or not. Time limit for an arbitral award under section 20A is given under two circumstances. If the arbitration is a domestic arbitration, it is normally 12 months. There is no change in that. But in the case of an international commercial arbitration, the time limit is not capped to 12 months. There is no limit for time, but you should try to complete within the 12 months. This is a loosening condition, or it is given a relaxation under section 29A for international arbitrations. Since the case is bigger, we cannot restrict the timeline. So this is the logic behind the difference in time limit. The next section is section 29B. This is a fast track procedure. In court, when you go, it will take years to complete. When you come to arbitration, primarily under section 29A, you can complete it within 12 months. 12 months primarily, and within 6 months you can get to further extension period. If you want to even more quicker solution, you can go to fast track procedure under section 29B. What is the fast track procedure? In this procedure, you will get the award within period of 6 months. And there is no extension under this section. In the 29A, we got an extension up to 6 months. In this, no extension. The time limit is capped within 6 months. The maximum time limit is only 6 months. There will be no oral arguments. Since we have to decide it faster, we can take only written arguments will be taken. Everything should be written and it should be given. Otherwise, it will not be taken into consideration. There will be a sole arbitrator. If you want to decide the case quickly, it should be a small case. Very big complex cases cannot be decided quickly. So when you can you have a small case, you can go under this section and there will be only one arbitrator. Award not given within time, section 29A will be applicable. If you cannot complete within 6 months, then what will happen? That section 29A will apply and you can complete within 12 months and you can get an extension of 6 months also. If 29B cannot complete within 6 months, then you can go to 29A. Oral arguments may be allowed by the tribunal if all party makes request or the tribunal considers it necessary. Generally, there are no oral arguments. If you want oral argument, all the parties concerned in the arbitration must make a request to the tribunal. Or else, if the tribunal considers it necessary, if the oral argument is required, like that the tribunal is thinking, then it can allow for oral argument. In the 29B fast track procedure, the fees and the manner of payment. For the fees, it is for the arbitrator. How much it should give, in what manner it should be decided, what manner it should be paid. This will be determined by the parties. The next section is section number 30, which talks about settlement. Tribunal may use mediation, conciliation and other procedures to encourage settlement. Tribunal will try to settle the arbitration dispute within you people itself. They will use mediation, conciliation, and they will try to patch up and settle the dispute between you two. If during proceedings, parties settle the dispute, tribunal shall terminate the proceedings. For example, if both the parties talk with each other and they come to a negotiation and they come to a settlement, you will pay this much, I will give this to you, like that they will come to a settlement. If the settlement is reached, the tribunal will terminate the proceedings. If the settlement is reached, the tribunal will terminate the proceedings. The proceedings will not happen further and the settlement is reached. If the parties request and not objected by tribunal, settlement may be recorded as an award. For this arbitration dispute, there is no award because the settlement is reached. If the parties request, both the parties should request the tribunal and the tribunal should have no objection. Then what will happen is the settlement itself will be recorded as an award. Then this will be given to the parties. The settlement will be given as an arbitral award as an outcome of the arbitration. The award passed under section 31 and stated as an arbitral award. This award they are giving it, right? This according to which section they will give? According to section 31 they will give the award. Then it is an arbitral award. Same status as any other arbitral award. Just because there is a settlement here, there is no special recognition or there is no special things for this award. This will be the same status as any other arbitral award. The next section is section 31. Form and contents of the arbitral award. When the arbitral tribunal is giving an award, in what format it should be, what are all the necessary elements in the arbitral award. This is given under section 31. It should be made in writing and signed by the tribunal's members. All the members of the tribunal, the judges, right, the arbitrators who are present in the tribunal, they should sign the arbitral award. If there are more than one arbitrators, the signature of majority of the members is required. If there are 3 arbitrators, then in the arbitral award, the mandatory thing is at least 2 people's signature should be there, majority. 2 out of 3 people's signature should be there. And one person, if the signature is not there, it is not a problem. But there should be reasons. The reasons should be given in the arbitral award. That's all. And the next point is award shall state the reasons upon which it is based, upon which conclusion they came to the award. That thing they have to give in the arbitral award. There are certain the situation where the reasons is not required. If the parties agreed that no reasons are required, then it will not be there in the award. If the award is under section 30, agreed terms, we saw it according to settlement, the award will be made. If the award is made by settlement, then no reasons should be given. Award shall state the date and place of arbitration, where the arbitration happened, the date on which it happened, that should be given in the award. Signed copy should be delivered to each party. It should be delivered to each party. If there are two parties, both of them will get one copy of the arbitral award. Tribunal may make an interim award. It may give an interim award also under section 17 for preservation of subject matter, or for preservation of documents, or for freezing the bank account, like that. Award of interest. Interest may also be awarded if the tribunal decides the interest is required. Tribunal may award interest. Interest at the rate of 2% more than the prevailing rates. As on the date of award, there will be a interest rate. Add 2% to that rate, you will get a percentage. That percentage interest the tribunal may award from the date of award to the date of payment. For making late payment, this is the penalty interest. Costs to be fixed by the tribunal. Any costs if are to be paid by any party, like that, that will be decided by the tribunal. The next section is for costs. You can read it in the book if you want. It is not so required, so I am not covering it here. Please do not avoid this section. You can read it in the book. 32. Termination of proceedings. Arbitral proceedings shall be terminated by final award or under section 32 subsection 2. There are two types of termination of arbitral proceedings. One is by above we saw award. If the final award is given, then the arbitral proceedings will be terminated. Or else under section 32 subsection 2, which will be studying down. Here it is. Under this section also we can terminate the arbitral proceedings. What is being said under subsection 2? Tribunal shall issue order to terminate the proceedings. Under three situations, the tribunal will give an order to terminate the proceedings. Claimant withdraws the claim. In the arbitration, we will have two parties. Or there will be many parties also. For simplicity, I am taking two parties. One party will make allegations on the second party. This is the problem, and for this only we are going to the arbitration. This allegation we have to prove, or we have to get compensation, or if the allegation is wrong, we should tell the party that allegations are wrong. For this only we are going to arbitration. If the allegation itself is withdrawn by party 1, then there is no need for arbitration. Parties agree for termination. Both of the parties come mutually and say that we don't want proceedings. Please terminate the proceedings. Like that they are saying to the tribunal. And the next situation is tribunal finds that the continuation is unnecessary or impossible. In certain situations, the continuation of the proceedings will be impossible. For example, in any case, if it is a arbitration for some kind of goods dispute, if the goods are destroyed by kind of a natural calamity, then it is unnecessary, and it may be impossible also in some situation to continue the arbitral proceedings. In those cases, the tribunal will issue an order to terminate the proceedings. The next point is for correction and interpretation of the award. If there is any mistakes, or if there is any point which is confusing in the award, you can get an interpretation from the arbitral tribunal. Award may be corrected by the tribunal within 30 days of receipt of the award. The date from which the party receives the order, from that date you can add 30 days. That is the time limit for correction by the tribunal. Party must request to correct any computation errors or clerical or typographical errors. There are two types of correction on its own by the tribunal. The tribunal itself can notice the mistake in the order and they can rectify it by themselves. Or there is another method on application by the parties. The party will make an application to the tribunal. There is a mistake in the order. Please rectify this. Like that. The party must request to correct the computational errors. For example, it is written in the arbitration award, it is that 2 plus 2 is equal to 5. This is a computational error which should be corrected. For this you can make an application to tribunal, and then any clerical or typographical errors can also be corrected. A party can request tribunal to give an interpretation of a specific part of the award. If you do not understand any part of the award, for example, if the award has 5 paragraphs, you do not understand one paragraph, in that you can go to the tribunal and ask the meaning for that one paragraph. Tribunal may correct or give interpretation within 30 days. Once you go to the tribunal and say that you have to correct the award or you have to make an interpretation, the tribunal will complete that work within 30 days. It will give an interpretation or make a correction within 30 days it will do. Period for correction may be extended by tribunal. The general time limit is 30 days, but the period of correction may also be extended by the tribunal. If the tribunal wants, it can extend the period also. And one more important point is when you ask the tribunal for correction or for interpretation, you should give the notice to other party also. One party, if he comes for the tribunal correction or interpretation, it should give notice to the other party also. The next section is section 33, subsection 4, arbitral award, additional arbitral award. Section 33, subsection 4. Unless otherwise agreed, a party may request the tribunal to make an additional award as to claims presented in the proceedings but omitted from the award. For example, if you go to arbitration and you are giving 5 problems, 1, 2, 3, 4, 5. These 5 problems we need a solution from the tribunal. But the tribunal investigates and passes an award. But only 4 issues solution are given in the award. Now you can go to the arbitral tribunal and get an additional award for the 5th point which is not covered in the award. Such request within 30 days of receipt of arbitral award. For this also the period is 30 days only. When you receive the award, within 30 days from that date you have to go and ask the additional award. Tribunal for making the additional award, the time for tribunal is 60 days from the request. The date on which you give the request plus 60 days. That is the time limit for additional award. For example, you give the request on 1 April 22. It is given 60 days, that is 30th May 22. This is the time. Within this period, the tribunal should give the additional award. It may also be extended. The next section is section number 34, application for setting aside the arbitral award. This is the section which is very important for setting aside the award. You can go to court, and if you do not like the arbitral award, you can make an application and the court will decide and it will say whether the award is correct or not. Subsection 1. Recourse to court can only be done by application to set aside award according to subsection 2 and 3. How you have to make the application, that is given under subsection 2 and 3. Award can be set aside only if, under which grounds, under what basis, by what underlying thing you can go and file the application. That is given here. Applying party furnishes proof that a party was under incapacity. If any of the party of the agreement or arbitration was under incapacity, he was unable to make any decision. If it is proved, then you can make an application to the section. Arbitration agreement is not valid, or party making the application was not given proper notice of appointment of arbitrator, arbitral proceedings, or was unable to present his case. If you were not properly represented in the arbitration, then also you can go. By you are not given the proper notice for the appointment of arbitrator, you are not given proper notice for the arbitral proceedings, you was unable to present the case. In this situation, you can give an application under section 34 for setting aside the award. You can also apply for lack or excess of jurisdiction. The arbitral tribunal made orders for matters which are beyond its jurisdiction. The arbitral tribunal does not have authority to decide on certain cases. That case is also, if the tribunal decides and gives an award, you can go to court for applying for arbitral award setting aside. Award deals with dispute not falling within the arbitration terms. In the arbitration agreement itself, it is not given that this issue can be decided by the tribunal. If that also the tribunal decides, then you can go to court. Decides on matters beyond the scope of arbitration. Composition of tribunal or procedure not in accordance of agreement. The tribunal composition, for example, in the arbitration agreement, it is given that one chartered accountant and one cost and management accountant will be the arbitrators. But if this is not followed, both of them are chartered accountants, or both of them are company secretaries, or both of them are cost and management accountants. In this case, you can go to court under this section. The next point is that if the courts find that in the above case, what we saw is that the party will apply to the court and it will furnish the proof. In this case, the application is required from the party. There are certain cases where there is no need for application. The court itself will set aside the award. The grounds are subject matter of dispute not capable of settlement by arbitration. For example, there is a murder case. This is settled by arbitration. This is a matter which should not be settled by arbitration, and you have to go to court compulsorily. If this is a case, then the court will set aside the award on section 34. Award is in conflict of public policy of India. If the given arbitral award is opposed to the public policy, then also the court will set aside the award under this section. There are two explanations for this section. Before that, we should understand that these are the discretionary powers of the court. The court need not mandatorily do it, but the court can do it. There is a power with the court for doing this action. Explanation 1. Conflict with public policy. What is the meaning by conflict with public policy? Award was induced with fraud or corruption. If there is fraud or corruption, then it is opposed to the public policy. Contravention with the fundamental policy of Indian law, against the basic notion of morality or justice. It is immoral or it is illegal, like that. If it is there, then it will be set aside by court. Explanation 2. Test to contravention of fundamental policy may not entail a review on the merit of the dispute. What is the meaning of review on the merit of the dispute? The meaning is that if you go into the details, what is the dispute, what did the claimant say, what did the respondent do, what did the arbitral tribunal follow the proceedings, you should not go into the details. For seeing whether it is opposite to the fundamental policy, you should look only at the award and you have to make a decision. You should not go deeper into the details. This is the meaning of explanation 2. The next point is patent illegality. Award may also be set aside if there is patent illegality is found. If the award is blindly illegal, if we can see it and we can decide that it is illegal, it is so apparently illegal, then you can set aside the award. The next point is time limit to challenge an award. In this case, what are you doing is that challenging the award. You are make an application to set aside the award. Application shall not be made after 3 months from the date of receiving the arbitral award. The date on which you receive the arbitral award, within 3 months you have to go and make this application. If sufficient cause found, court may entertain application within further period of 30 days. 3 months is the general period. If you have proper reason, the court will also take into account delay of 30 days. It will give you 30 days extra time to make the application. Court may adjourn the proceedings if it deems necessary. Court may also adjourn the proceedings if it requires the proceedings to be adjourned. Application under this section be filed after notice to other party. If you want to file an application under section 34 for the arbitration, you have to give notice to the other party also, accompanied with the other party affidavit. The other party should also give an affidavit that he gave a notice to me. Like that, you have to get an affidavit also. The application must be disposed within a period of 1 year. For example, if the court receives the application on 1st April 22, it should be disposed within 1st April 23. This is the time limit for taking a decision under section 34. Time limit for court. The next section is section 35, finality of the arbitral awards. The arbitral award given by the tribunal shall be final and binding on the parties claiming under it. And the next section is section 36, enforcement. It should be enforced as if it were a decree of the court. For example, if a court issues the order, in what way it will be implemented? The same way the arbitral award will also be implemented. For example, an arbitral award is given and you go to court under section 34 for setting aside the award. Just because you gone to the court, the implementation of the award will not be stopped. It will be implemented if only if the court gives a stay. Expressly the court is giving a stay to stop the implementation. Only then the award will not be implemented. No automatic stay of the arbitral award. It will be generally implemented, no matter whether you file the case under section 34 or not. The next section is section 37, appealable orders. We saw under section 34 that you can challenge an award and you can go to court for setting aside the award. But you can go to appeal only under certain orders. I already told that the list is given under section 37. This is section 37, appealable orders. You can go to appeal only against these orders. Refusing to refer parties to arbitration under section 8. Granting or otherwise of measure under section 9. Setting aside or otherwise of order under section 34. Under section 8, the court can refer the parties to arbitration. If the order under that section by the court, whether they are referring you to arbitration or not, if you want to appeal to that order, you can make an appeal. Under section 9, you will go to court for an interim measure. If the court grants you interim measure or does not grant you interim measure, you are aggrieved, you are not satisfied by the decision, you can go to court for this appeal. Setting aside or otherwise of order under section 34. If you go under section 34 for setting aside an arbitral award and the court is telling, I will not set aside this award, the award is proper, you can go to the appeal. The next point is that an appeal against tribunal shall lie accepting the plea under section 16 subsection 2 or 16(3). Section 16 was for jurisdiction of the tribunal. Remember, the jurisdiction of the tribunal can be decided by the tribunal itself. If you say that the tribunal does not have the jurisdiction, it is up to the tribunal to decide whether the jurisdiction is there or not. If the tribunal takes a decision on this and you have to go and appeal on that decision, you can go under this section 37. Granting or otherwise of measure under section 17. Under section 17, interim measures will be given by the tribunal. If the tribunal refuses to give you the measure, you can go to court and get an appeal. No second appeal shall lie from above appeal. Under this section, if you are going to an appeal and that decision is the final decision, you cannot go another appeal on the decision under section 37. The next section is section number 40. Arbitration agreement not discharged by death of the party. Arbitration agreement is not discharged by death. Even if any one of the party dies, the case will be carried on by the legal representative or the legal hire and it will not end. Mandate of arbitrator is not discharged by death. If any one of the party dies, the mandate of arbitrator, the office of arbitrator will not be terminated. Nothing can affect the operation of law. This is the operation of law and no one can affect it. The next section is confidentiality of information. Section number 42A. Maintain confidentiality except award where disclosure is necessary. You have to maintain the confidentiality. One of the main reasons where we come to arbitration is for confidentiality of information. You have to keep the things in secret. Only when the award is given, you have to mention the details in the award. Otherwise, you have to keep the details confidential. This instruction is for arbitrator, the parties, and the arbitral institution also. They should keep the things confidential. The next section is section number 42B, protection of action taken in good faith. No legal proceedings against arbitrator for having done something in good faith or intended under this act. If the arbitrator does something in good faith, you cannot make a case against him for doing that action. The good faith of the arbitrator protects him from any cases being filed on him. Now there is one more section called section number 43 which talks about the limitation period. This is not so important and you can read it in the book. That's all. This is the end for chapter 4, the fundamentals of arbitration. The chapter 2 of the Arbitration and Conciliation Act as given in the CA final self-paced online module set C. Happy learning. Please revise this topic in regular intervals before your set C examination. Thank you for watching this video. Thank you.